Now, another delay in the murder trial of soccer star Senzo Meyiwa, this as Judge Tshifhiwa Maumela is sick and won't be able to continue with the trial, but arrangements have been made for the continuation of that trial, but that will only happen next month. Let's break things down now with legal expert Mpumelelo Zikalala, who joins us now virtually. Thank you very much, Zikalala, for your time here on eNCA. Just first of all, we all know that everybody has a right to sick days. Everybody, you cannot just assume that a person, when a person calls in sick, that they are lying, right? But this, at the same time, coming from the cloud of what the JSC said in terms of the recommendations to have him go under a DC and a tribunal, etc. Does this play anything, especially with the trials that he presides over, rather? Maybe the victims or the people on trial in those cases questioning themselves?
I wouldn't think so. I think the person's health is something which is beyond their control. You can't really expect that today or predict that today I'm going to be sick. So I think let's give the judge the benefit of the doubt and say it's something which is beyond your control. But I did expect that when the JC made that pronouncement, due to the magnitude of this particular case and especially the type of attention that it has been able to bring, maybe let's leave the attention alone. Take into account that it's been 10 years since the incident took place and we need to find closure as soon as possible. I would have assumed that the judge president would have said, let me remove you from this case. There's only 3 witnesses that have presented their case. They would need to come back, obviously, because the matter would have to start de novo. But it's better to start off with 3 witnesses than 3 or more witnesses when you need to start the trial from scratch. So I would have expected that what is about to happen now would have happened earlier. So you wouldn't even heard the evidence of Ms. Kelly Khumalo's sister. You would have started with the re-examination or the recalling of the witnesses that have been there. You may find that in certain instances, if you employ the legal representation to say, are you finding each other in terms of what is common cause with the evidence of this witness? Do we really need to bring them in to explain from start to end, or are there certain things in which we are then agreeing to? The sort of short of curtails the matters in which are in disputes, and when you call them back, there is simply confined to those particular processes which are in dispute, because at the end of the day, the legal representative have not changed. It is only the presiding officer that has changed. But you can't short-circuit the process. You need to call them back, every single witness that have given evidence earlier, and so that they're able to bring the new evidence in the eyes of the new presiding officer, which would have replaced the judge.
All right, so with the fact that it's expected to return on the 17th of July and run throughout the 3rd term, what you're saying right now could be what we see happen, right? The investigating officer that was first on the stand, Senzo Meyiwa's first friend, Mpumelelo Zikalala, as well as the latest one who had actually testified, they might be called back.
Definitely. If there's a new judge who's going to come in, they might be called back and would say to them, can you please go and repeat the same type of evidence in which you've repeated earlier? It doesn't mean, though, that you're going to be spared from any cross-examination that would have taken place. You are still going to be cross-examined when you simply want to hear one thing. Are you going to be able to repeat, if not verbatim, because no human being can be able to do that, the type of the manner in which you presented evidence earlier. And if there are any inconsistencies that can be raised or that are raised, there's a time in which they are going to be raised during cross-examination. But it cannot be that we are simply going to take the evidence that you presented earlier and transfer it to the new presiding officer without you going to the witness box. That's what we may see. But it does not always guarantee that if you sit down and trial for a longer period, you'll be able to move faster. What is required in any trial to move is that all the participants must be there. The presiding officer, legal representatives, the accused, and even the witnesses. If you have one person who is missing there, then the whole thing collapses, which is sometimes a danger in even recording or maybe saying that matters must be set down for the whole quarter, for example. It does not always work. So it's a number of things that come about. All you have to do is that once the date has started or once the trial has started, in terms of the days that have been allocated, use the timing wisely. So instead of starting maybe at 10, I would have said start at 9:30, end at 3, so that those few extra hours that you're able to build in will be able to cover lost time.
So there's absolutely no way to avoid calling the witnesses back, like, for instance, the court system where evidence is recorded, through microphones, etc., and then maybe the new presiding officer listens to that evidence and then says who he would like to return to clarify a few issues. That's not possible at all.
It's not a step that has been done in our courts. It may be something that can be explored, but we must be careful because we don't want anything to query at a later stage in terms of whether the particular trial was done in an authentic manner. So to prevent any type of injustices from taking place, prevent any type of application from coming at the end of the state case or even at the end of both the state and the defense cases, is to say, because we have a new judge, we are going to start from scratch. Here's the new judge sitting, listening to the matter. Over to you, state for the first witness. Remember when you give evidence as a witness that we are still going to remember what you stated earlier. All that we needed to do is to regurgitate whatever evidence that was there. The presiding officer is there to make sure that they are able to curtail any type of cross-examination which could be viewed as being time wasted or trying to answer questions that have already been answered in the earlier stages, or where questions have been agreed to in terms of saying this is a common cause, this is not in dispute, we're not going to ask this type of questions. There are certain admissions that can be made by the accused, so that sort of curtails the type of questions that can be there. But you need to call them back so that they're able to sit here, give evidence to make sure that the trial in which you're conducting is one which is beyond approach and procedurally, and everyone has been given a chance in order to cross-examine, to put the evidence across, and to make sure that when the time comes for the presiding officer to adjudicate the matter, all the facts and the relevant elements are in their hands, and they can be able to bring out a judgment at the end of the day.
Mr. Zikalala, of course, this trial we've seen, it's been out in public, it's had quite a few applications in it, you know, and judgments have been made with those applications by Judge Tshifhiwa Maumela, particularly when it comes to the presence of the media in this particular case. Recently, the sister to Kelly Khumalo applying for the media to not be inside or not record, rather, live proceedings of her testimony. And there was judgment there in that particular application, and obviously the media was allowed to stay and record only her voice, etc. Bringing in a new presiding officer, where does that put all the judgments that have been made within the applications in this trial?
Well, you could say those judgments would then be set aside and new applications can come in if you so wish, but it's not going to sway the minds of the court or the manner in which things have been proceedings. You should also understand that when it comes to certain matters, things are almost standard. So when it comes to access of the media to court proceedings, it's a general rule. The doors of the courts are open to everyone. Every single person who wants to sit in the public gallery can go and sit there. The only thing that we try to do when it comes to limiting what type of coverage is covered by the media is to say, we want to make you feel protected as a witness, and we also want to extract the most important thing, why you are here. You are not here for visuals. We are here for what we're going to say. So let's extract that and be able to allow the people at home to be able to hear what you have to say. So if we are going to come back and deal with standard procedures that have been decided way before in a number of cases, even before this one, then that's definitely time wasted. And I wouldn't even suggest that the legal practitioners or witnesses that are still yet to come must come and make those type of applications. They would be frivolous according to me. You're asking something in which the court has pronounced on before. It may be a different judge, but definitely the court has decided that this is the type of things or the manner in which things have to go. They simply abide by it. It covers everyone. It covers your right. It covers the court's right. So we're all fair and square.
All right. And lastly, Mr. Zikalala, and this is, not necessarily a legal question, but of course, there's been quite a lot of cloud over this case. It's 8 years old, like you said, and there's questions about whether or not the family will actually find closure. And now there's, a new presiding officer that is going to preside over the case from the 17th of July. How important is it for the public, especially for the interest of justice, for persecution and prosecution not to be a huge debate, especially persecution? We all know how it's been in South African law and South Africans' opinions.
It's very important, but you also have to realize that the wheels of justice sometimes grind at a very slow pace. And there's certainly going to be a few learning experiences, especially from this case, to how not to handle certain matters. So let's allow the process and then say, I know it's going to take time. Let's allow the new presiding officer, if he or she is going to come in, sit in, being able to listen to the evidence which is going to be presented to them. Now, just let all the stakeholders, which are very important, to make sure that they're able to live up to their game and make sure that they do the job in the manner in which they need to provide it. From the NPA, make sure that there are no time wastages. Witnesses are always available. They've always been prepped. When it comes to frivolous applications that have to be made, you think of other means of doing it rather than the old way in which it has always been done. And maybe just look at combining those two dockets so that you have a clear, much more clearer list of witnesses which are going to be there, taking into account the burden of proof that you have as a prosecution, which is proof beyond reasonable doubt. For the defense, stick to the type of cross-examination which will curtail matters. Don't ask questions which are not going to assist the court in any manner. Increase the number of hours that are there. Now, you see, in that aspect, it's every single stakeholder coming together and saying that our only interest is to make sure that we find the truth on behalf of Senzo Meyiwa and his family. And part of that is to make sure that we don't waste time. But let's understand, the wheels of justice, sometimes they grind slow, but it's much better if they grind slow than if they don't grind it on.
All right. Thank you very much for speaking to us. Mpumelelo Zikalala from Zikalala Attorneys, they're a legal expert, just giving us his thoughts on the postponement yet again of the Senzo Meyiwa murder trial.